Welcome to the Law to 10. I hope you find this course very well, and I hope you also in the good condition and with the best spirit and health. I'm going to introduce you with the next subject about offer. This is actually session 4 or lecture 4 for the week 2. Who is actually the parties that involved in the contract? There's offeror, which is person who proposed the contract. There's offeree, the parties to whom the proposal is made. In this example, if A makes an offer to sell car for certain value, for instance 35,000 ringgit to B. Offers. What is actually an offer? In Oxford Dictionary of Law, define an offer as an indication of willingness to do a refrain from doing something that is capable of being converted by acceptance into a legally binding contract. Offers therefore generally refer to a willingness to do or not to do something. Offers are usually made with respect to underlying terms or condition of an agreement. You can say offer of a price. Offeror is actually the person who is making an offer. For example, Suzanne, for example, is offering to buy Jane's car for 5,000 pounds sterling. Meanwhile, offeree is the person to whom the offer is made. In the example above, will be Jane. Offer is then an act or a statement that propose definition or define term and permits to other party to create a contract by accepting those terms. You can say several problems with intents, such as invitation to bargain is not an offer. Price quote is generally not an offer. An advertisement is generally not an offer. Placing an item up for auction is not an offer. It is merely a request for an offer. Problems with definiteness in the case of the term of the offer must be definite. You will see a sample of invitation to treat on page 5 of the PPT slide that I share with you. There's also some example where offers distinguish from invitation to treat. An offer is not the same thing as an invitation to treat. An invitation to treat is essentially an invitation to someone to make an offer. It's not an offer. This invitation or offer can either be accepted or rejected by the offeree. In the Pharmaceutical Society of Great Britain versus Boots Cash Chemists Limited in 1953, this is actually the case where items display for sale. These are actually invitation to treat. In the case of Fisher versus Bell in 1961, held that displaying a flick knife with a price tag in the shop window was an invitation to treat and not an offer for sale. In the case of Harris and Nickerson back in 1873, it was held that an advertisement giving details of a forthcoming auction was not an offer, but an invitation to treat. Make an offer, upheld in Partridge versus Crittenden back in 1968. Shop display, catalogs, and advertisement. What about that? In the articles displayed for sale and advertisements are invitation to treat and not an offers as well. However, reward posters are considered to be offers, as outlined in Carlyle versus Carbolic Smoke Ball Corporation. This case was in 1893. Offers, there's 5 key rules relating to offers. In regards to offer, first one, an offer might be made to one or more parties. Second thing, offers need not to be made in writing. The offer must be communicated definitely so people can aware of. The fourth one, revocation of an offer. There's potential. Yeah. Last one is other ways of terminating an offer. An offer might be made to one or more person. In the case of Carlyle versus Carbolic Smoke Ball Corporation in 1892, a company advertised a flu cure. They said in the offer that if you use the remedy and then suffer from flu, they will give you 100 pounds sterling. They then put 1,000 pounds sterling in the bank to show sincerity. A woman used to it and caught flu. She argued that the company should give her 100 pounds sterling. The court held then that an offer can be made to many people. It need not simply be between two people. The advertisements are not usually offers. However, the company that intended it to be an offer because they deposit 1,000 pounds sterling in the bank. In the case, offers need not be made in writing. Why? Because writing is a form of evidence that an offer has been made, but it is not a requirement. Therefore, oral offers and offers made by gestures, action, for example, are recognized. The offer must also be communicated. The offeree must be made aware of the offer. So the offer must be effectively communicated so that a contract can be born. What about revocation of an offer? Revocation of an offer refers to its termination. However, an offer can only be revoked if the offer has not yet been accepted. The offerer must be communicate the revocation to the offeree. This is actually an example of Briney versus Van Tienhoven back in 1880. When someone pays to make an offer for a certain amount of time, for instance, an advertisement in a newspaper, then the offer cannot be revoked until that amount of time has elapsed. Otherwise, of ending an offer, in this case, offer might also be terminated by one of the following ways. First, you can refusal. The offeree refuses to accept the offer. The second way is to counter-offer. When there is offeree rejects the offerer's original offer and then makes an alternative or counter it, the offer for the offerer to consider, then the original offer can also be varied, in which case the new offer will also be considered as a counter-offer. What about lapse of time? Lapse of time can be a way for ending an offer. The offerer can state that his offer will only exist for a certain amount of time. But if he does not state a time period, the offer will last for a reasonable period of time. This will vary according to the facts. And the last thing is actually a debt of either party. However, if the person accepting the offer does not know of the offeror's death and the deceased offeror representatives are able to carry out of the contract, then the offer will not end. Thank you very much for listening this course and attending this reading this material and go further beyond this PPT slide. I hope you enjoy and learn a lot from this course. Thank you for having me and see you next time.